an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. Today, we will be addressing matters such as bond. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. Those who receive a surety or cash bond today will be reset to the SAP calendar on April the 5th of 2022. Those receiving a signature bond will be reset for the notice to a division judge. Who do we have first?
Good afternoon, Judge. We're going to start in courtroom 2 with position 11.
All right. Is this Brandy House?
Yes, ma'am.
Good afternoon. Your case is 22 CR 001664G, in which you're charged with 1 count of loitering and prowling and 1 count of giving a false name to a law enforcement officer or other false information, with an offense date of March the 22nd of 2022. I've advised you of your constitutional rights. Do you understand them?
I do.
You said yes?
I do.
Do you object to a video hearing today?
I don't.
And do you object to your attorney helping you by video?
I don't.
All right, thank you. Ms. Kim, is this your client?
Yes, Your Honor.
All right, good to see you, Ms. Kim. Good afternoon.
Thank you.
Mr. Howard, good to see you as well. Can I please have this history?
27 total. Last was back in November, public indecency, criminal trespass. Before that, he was convicted for possession of a Schedule 2 controlled substance, trespass, disorderly conduct from 2019. Got a 2019 arrest on MARTA, 2019 probation violation, 2019 simple battery conviction, 2019 trespass arrest, 2019 trespass conviction. There's a lot of trespasses in there. 2018 trespass conviction. Now he got a $5,000 pretrial bond.
You say he's on that now?
Yes.
Okay, thank you. Whose case is this for the state?
This is my case, Your Honor.
Good to see you, Ms. Webb. What is the state's recommendation?
Yes, Your Honor. The state is recommending an increase for the surety bond, Your Honor, with $1,000 for the false name and $500 surety for the loitering charge with a stay away at the incident location at 3665 Martin Luther King Drive, and no alcohol, drugs, or weapons, Your Honor. As you've heard from pretrial, this defendant is a repeat offender. In this particular case, Atlanta Police Department did respond to the prowling call, and the defendant was found at that incident location loitering on the property with his shirt off and hiding behind customers' vehicles and harassing them, which was reported to the business. The defendant was at the location for an extended period of time without making a purchase, and when the officer requested the defendant's name, he gave the officer a false name. The state is still investigating this incident, Your Honor, to figure out what exact information that the defendant did give to the responding officer, which we will address at a later date. But for this particular proceedings, we are asking for an increase considering the defendant's history. Nothing further.
All right, thank you, Ms. Webb. Ms. Kim?
Yes, Your Honor. Mr. Brandy is 37 years old, and he has been here in Georgia for all his life. And he has 3 children here, 19, 17, 12. He is not married at this point. However, he has parents here in Georgia. He has a job. He's been working at security industry for about 5 years. He has a high school graduation diploma. He didn't go to college. He does not have any other issues, so we would like to request for, considering the fact that he has 27 cycles, we would like to request for very, very low bond of the maximum $500, Your Honor.
Ms. Kim, you're saying a maximum of $500. You're asking for $250 on each charge?
Yes, ma'am.
Okay. All right, thank you. All right, anything further from either party before I issue my decision?
No,
Nothing
Your
further
Honor.
from the state, Your Honor.
All right, at this time, the defendant is going to receive a $1,500 surety bond, a $1,000 surety bond for giving the false name, $500 for the loitering and prowling. He is to stay away from the address on Martin Luther King Jr. Drive, and he is to have no weapons, drugs, or alcohol as a condition of this bond. Anything further from either party?
Nothing further, Your Honor.
Nothing further.
All right, if not, best of luck to you. We can move to the next defendant.
Position number 9, position number 9 in courtroom 3.
Okay.
Thank you. That's the judge right here, Judge McWilliams, okay?
I'm not sure if this defendant has heard her rights, so we'll go through it again. Are you Kathy Grigley?
Yeah, my maiden
Okay.
name is.
Is that you? That's your name? Yes, ma'am. Okay.
And
You were not, I don't believe you. I'm sorry.
I said, I've been using my maiden name, but my marriage name is Jackson.
Okay. I don't believe you were on the screen, so let me advise you of your rights. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Who represents Ms. Grigley?
I do, Your Honor.
Oh, it's good to see you, Mr. Ford. Long time. And your attorney, Mr. Charles Ford, is present here on the Zoom conference to assist you. Do you object to him appearing by Zoom or to me conducting this video hearing by Zoom? So basically, I'm asking if you have any problem with it.
No.
Okay. Your case is 22 CR 001657F. You're charged with 1 count of theft by taking and 1 count of criminal trespass, each with offense dates of March the 16th of 2022. All right, Mr. Howard. Oh, first pretrial jail. Was this first?
No,
Okay, history, Mr. Howard, please.
7 total. 2013 simple battery arrest. 2007 was before that one, probation violation. 95 trespass. So everything's old.
Okay, thank you. All right, Ms. Webb, is this your case as well?
Yes, Your Honor, it is. And this particular case occurred on March the 5th, 2022, when Atlanta Police Department responded to a trespass call at 2598 Browns Mill Road Southeast, where they were met by the victims, Miss Myrtle Davis and Miss Clunis. I believe that's Clunis, Clunis, Davis, common spelling. And for the record, Myrtle is spelled MYRTLE, Davis, common spelling. The victims informed the officers that they were pulling up to their residence when they witnessed the defendant sitting in a car in front of their home. They recognized that vehicle from previous incidents where mail and packages were stolen from the home and their mailbox was damaged by someone driving that same vehicle. The victims informed the officer that a Black female with dreads wearing a bandana and a white t-shirt exited the vehicle on this particular incident and reached inside of the mailbox, but that mailbox was empty at the time. When they confronted her, she told them that she was checking her mail and that she resided at the residence, in which they told her, of course, that is false, and they told her to leave, and the defendant allegedly told them that she would kill them. The victims were able to get the tag of that vehicle, which is how the officer was able to identify the owners of the car, which included the defendant and her daughter. Your Honor, for those reasons, the state is recommending a $1,500 surety for each count, a stay away from that incident location at 2598 Browns Mill Road Southeast, no further contact with the victims, Mr. and Miss Davis, and no alcohol, drugs, or weapons while out on bond. Your Honor, the state does believe that the defendant has a risk of reoffending. As reported by the victims on previous incidents, APD was dispatched to the scene for similar offenses where they were reporting missing mail and packages, but at the time, there was not sufficient identifying information to identify who the culprit was in those cases. But they did say that they had a previous run-in with that same defendant where she told them that the famous rapper 50 Cent lives at that residence, and that is why she keeps coming back. The victim also advised that the defendant lived at apartment on a Mount Zion Road, in which they were able to acquire that information based on their own research. As you've heard from pretrial, the defendant does have a conviction from 1995 out of Clayton County for trespass, albeit that is a remote conviction. We do believe that it does point to the fact that the defendant has a propensity for these types of actions, Your Honor. For those reasons, the state is making that $3,000 total surety bond today. And also, Your Honor, I believe the victims, Mr. or Miss Davis, one of them is present on the call today.
All right, thank you. Mr. Ford?
Well, first of all, Your Honor, we want to totally disagree with the solicitor's assessment that there's that there might be an act of reoffending. at this point, the last offense was 2013. Before that, 2007, and before that, 1995, Your Honor. My client is 54 years old. She's a high school graduate. She's presently on Social Security and receiving payments. As quoted from her, she has plenty of adult children. She does have a valid driver's license. She's lived in Georgia her entire life. There's no risk of a flight here. She has given me a telephone number for a daughter, so she has plenty of community support, Your Honor. And pretrial services already recommended that this person should get, Ms. Grigley should get an unsecured judicial release. Your Honor, we're reaffirming that Ms. Grigley is, and then this is not even a violent crime. And my client totally denies the charges. So at this point, Your Honor, we feel a signature bond or some type of unsecured judicial release would be appropriate at this time.
Thank you, Mr. Ford. At this time, I'd like to sound for the victim, last name Davis. If you would like to be heard or make a brief statement to the court, this is your opportunity to do so. I would need you to turn on your camera and your audio such that you could speak at this time, but you are not required to do so. All right, last call for victim, last name Davis. All right, hearing none. At this time, Ms. Wrigley's going to receive a split bond. On the theft by taking charge, that's going to be $1,000 surety bond. And as for the criminal trespass, that is going to be $1,000 signature bond through the jail. She, on both bonds or both charges, she is to stay away from 2598 Browns Mill Road Southeast. Have no further contact
My
with
house, that's my house, and I'm not gonna stay away because, like I said,
Ms. Grigley, stop.
She is to stay away from, I'm going to finish and then I'll speak with Ms. Wrigley. She is to stay away from that address. She is to have no further contact with the victim's last name Davis, and she is to have no alcohol, drugs, or weapons. Ms. Grigley, if you wish to say something, anything you say can and will be used against you. The best thing for you to do is to contact Mr. Ford to clarify any issues as it pertains to this bond, all right?
And I would advise you, Ms. Grigley, not to make any comments.
oh no, this is my house, and they got all my belongings in their house. That is my house, and they know that. Mr. Davis do not say that. That's a stalker. He been stalking 50 Cent mother.
Miss
Your
Grigley.
Honor, I'm sorry to interject, but can we have a breakout session, please?
Yeah, I was gonna suggest that as well. Can we
Yeah.
be put in a breakout room? It will be me, Mr. Walker, Ms. Webb, Mr. Ford, and Ms. Kim, I believe, may want to listen.
Okay.
Kill a meal.
Yes,
Them
Your Honor.
stalkers. Put your mask on. Then you stop around my house at 2598 Brown Mill Road. Y'all don't want nobody messing
No,
with
they're going to a
y'all.
breakout.
I mean, they don't want nobody messing with their house.
Courtroom 2, can you look in the chat, please?
All right, Ms. Wrigley's bond will remain as previously set and stated. And I believe we've addressed all outstanding issues with her counsel. And hearing nothing further, we're done with Ms. Wrigley's case. Best of luck to you, ma'am.
Your Honor, the victims are on the call as well. It looks like they appeared.
I've sounded for the victims. They had their opportunity to speak. We are going to keep moving at this time. Thank you, Ms. Webb. All right.
You have the wrong people at my house.
All right. We are going to move to the next position.
All right, we got position number 2, Mr. Boykins.
All right. Good afternoon, Mr. Boykins. Your case is 22 CR 001651E, and what you're charged with loitering, violating an ordinance, and theft by shoplifting with an offense date of March the 22nd of 2022. I'm not sure that you all heard your constitutional rights, so let me do them again. You have absolute right to remain silent. Anything you say regarding the facts of this case can and will be used against you. You also have a right to an attorney at this proceeding. Do you object to your attorney assisting you by video today?
Oh, no.
Do you object to your this hearing being conducted by video?
Oh, no.
All right, thank you. Who represents Mr. Boykin?
I do, Your Honor. Charles Ford.
All right, thank you, Mr. Ford. All right, Mr. Howard.
April 2021 trespass conviction, DeKalb County. February 2021 trespass conviction, DeKalb County. January 2021 trespass arrest. 2019 FTA, theft by taking, hit and run. He was convicted for theft by taking 2018. Got another 2018 theft by taking conviction. And a 2018 shoplifting conviction.
All right, thank you. Ms. Duncan, is this your case?
Yes, Your Honor. Good afternoon.
All right, good afternoon, good to see you.
This
What is the state's recommendation?
The state's recommendation in this case will be a $3,000 total surety bond. That's $2,000 for the theft by shoplifting and $1,000 for the loitering. In this case, Your Honor, the defendant appeared on the property of a closed auto service business at the incident location of 2525 Riverdale Road. And that business was closed, and he was found sitting inside of what officers described as a white Mitsubishi Galant for no particular reason. And then the second incident, which is the theft by shoplifting. The defendant entered the store of Family Dollar. One second, my apologies. Entered the store of Family Dollar and took into his possession and concealed in a bag a bottle of Blue Magic hair grease, and left the store without paying in an attempt to deprive the owner of the merchandise. Given the defendant's history, we are concerned about the risk of reoffense in this case. As pretrial has stated, this defendant does have several arrests for theft-related offenses as well as convictions due to that. We are requesting the bond with the conditions in addition to, my apologies. In addition to the bond, as stated, we'd like a stay away from both locations, the auto shop and the Family Dollar, which is located at 2461 Riverdale Road, and no alcohol, drugs, and weapons.
Are both locations at that 2461? Is it like a plaza, or are there two separate stay away addresses, Ms.
I'm not sure, but I have two separate stay away addresses.
So what's the other stay away? I have 2461 Riverdale Road. What is the other one?
And the other one is 2025 Riverdale Road.
Okay. Thank you. Mr. Ford.
Thank you, Your Honor. Your Honor, we're asking that my client receive a signature bond on each count as been recommended by pretrial services, that an unsecured judicial release is recommended. My client is a lifetime resident of the state of Georgia. So he's not at risk of flight. He has plenty of community support. He has 2 children, 1 boy, a girl, boy 2, girl 3. He's given me his father's name, which is Terrence Boykin Senior, and telephone number. So he has plenty of community support. As you will note, that even mentioned by pretrial, these are not violent crimes, Your Honor. As far as any risk to society or the community, we believe that a signature bond would work in this case, and he just get to stay away from those locations.
All right, thank you, Mr. Ford. At this time, Mr. Boykins is also going to receive a split bond. On the loitering, he is going to receive $1,000 signature bond through the jail. He is to stay away from both addresses on Riverdale Road. On the theft by shoplifting, he's going to get a $2,000 surety bond. With those same stayaways, he is to have no alcohol, drugs, or weapons as a condition of these bonds. Is there any further questions from either party?
Nothing further from the state.
Your Honor, my client cannot afford that. He is not working at this time. That's why I believe that the signature bonds would be effective with the stay away. I mean, the 2,000 surety bond could be a number that my client cannot bond out of jail.
And the state would have.
He'll be reset to the SAP calendar on April the 5th if he can't make it by then, where this bond can be revisited at that time. I will not be bonifying the bond. Anything further from either party?
Nothing else, Your Honor.
All right, best of luck to you, sir. We can move to the next position.
No,
you're wrong.
I'll talk to you. I'm gonna talk to you.
Yeah, you gotta sit, you know, why not? I know you gotta split.
Clark, come on. We got position number 4, Mr. Clark, position number 4.
Okay. All right, good afternoon, Mr. Clark. Your case is 22 CR 001668Y, in which you're charged with willful obstruction with an offense date of March 22nd of 2022. I've advised you of your rights. Do you object to the video hearing?
Say again, ma'am.
Do you object? Can I conduct this hearing by video today?
Yes, ma'am.
Do you have any objection to your attorney helping you by video?
No.
Thank you. I appreciate that. Mr. Howard.
6 total. Last arrest was 2020, sale of marijuana, possession of a knife or a firearm during the commission. That's open in Cobb County. On probation in Fulton, theft by receiving, 19 SC 165050. 2019, they gave him 5 years probation for that. 2019, FTAs for ag assault, a deadly weapon, armed robbery, hijacking motor vehicle, possession of a firearm during the commission, robbery.
Okay, I think that's good. I think that should be all 7 cycles, right? 1, 2. Okay, thank you, Ms. Howard. That's good. All right, Ms. Duncan.
Yes, Your Honor. Incidents in regards to this allegation took place yesterday on March 22nd, 2022 at 3657 Martin Luther King Jr. Drive, which is a Citgo gas station. Officers were in the area working a crime suppression detail on the block where that Citgo is located. The defendant was located at that address, and when officers pulled up, several of the individuals at the location began to flee on foot. Officers were able to apprehend several of the people there, and the defendant was one of those people. And because officers also believed that there was some narcotic activity going on at the time. Officers asked the defendant his name, and he advised initially that he would not give his name. And so therefore, by saying he could not do that. So therefore, officers placed the defendant under arrest. And when they attempted to arrest him, he became tense and physically resist arrest by pulling his hands away and attempting to flee. Given the defendant's history with FTAs and criminal convictions, we also located that the defendant is wanted out of the sheriff's office in Marietta Due to these facts and circumstances surrounding these events, we are requesting a $2,000 surety bond, a stay away from the incident location, and no alcohol, drugs, or weapons.
Okay, thank you, Mr. Ford.
Thank you, Your Honor. Your Honor, my client is 23 years old. He's a high school graduate. He has 2 jobs, Your Honor. He works at the Citco on Martin Luther King. He's been there for 2 months. He's been a private contractor for Auburn State for 7 months. He's a lifetime resident here in Georgia. He definitely has support in the community because he does have a 7-month-old girl, a little girl that he gave me the baby's mother as one of his contact individuals. He has a stable address here in Georgia and telephone number. He does not have the violent types of crime, Your Honor. This situation here is, there's really no underlying offense. The police officers suspected that there was an incident going on. My client didn't feel that at this point he had to give his name at this because there was no underlying offense. So at this point, I think he has a true defense on this matter. On the open case in Cobb County, I believe he should get a signature bond so he can go and deal with that particular situation, so he can keep his employment, so he can continue to provide financial support for the 7-month daughter at this time, Your Honor. So we're requesting a signature bond or some type of unsecured judicial release.
All right, thank you, Mr. Ford. At this time, Mr. Clark is going to receive an $8,000 signature bond through the jail. He is to stay away from the incident location and have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further from the state.
Nothing further, Your Honor.
Thank you, ma'am.
All right, best of luck. Best of luck to you, sir. And who do we have next?
Position 10, Mr. Hamilton.
All right, at some point, can we take I see a Ben, we can take Mr. Hamilton, but after Mr. Hamilton, are we able to take?
Position number 13 on the calendar.
Yes, are we able to take position 13 after we take this position, please? All right, good afternoon. Are you, please pronounce your name for me, sir?
It's Irish.
Irish Hamilton Mercano, is that your name?
Yes, ma'am.
Okay, your case is 22 CR 001670F, in which you're charged with 1 count of battery family violence with an offense date of December the 9th of 2021. I've advised you of your constitutional rights. Do you understand those rights?
Yes, ma'am.
Do you object to a video hearing today?
No.
Do you object to your attorney assisting you by video?
No.
All right, at this time, Mr. Howard.
20 total.
How many? I'm sorry, 20?
Yes.
Okay.
Last arrest was 2021. Felony theft by receiving. Misdemeanor possession of marijuana. That's 21 CP 198138. 2018 probation violation. Another 2018 probation violation. It was a bail jumping with that charge. It was dismissed. Another 2018 probation violation, 2017 probation, 2017 battery conviction, 2016 a freight conviction, 2015 probation violation, 2010 simple battery dismissed, 2010 FTA loitering or problem dismissed, 06 robbery dismissed.
Okay, thank you. Ms. Webb.
Yes, Your Honor. This incident took place on December the 9th, 2021 at 2479 Abner, that's Abner, ABNER Terrace, Northwest, Unit 227, Atlanta, Georgia, where Atlanta Police Department responded to a domestic dispute call and were met with Ms. Satoria Jones, that's Satoria, SATORIA Jones, common spelling, who informed the officer that she and the defendant were married at the time and shared 1 child together and lived at the incident location together. The two had a dispute over doing chores around the home. She went into her car sometime after that dispute to have a conversation with her mom, and she informed the officer that she did not recall what happened after she exited the car and entered back into the home, but a physical altercation did ensue where the defendant bit her finger, and during that struggle, Ms. Jones did sustain bruising to her face and neck area, but she could not report to the officer how those bruises occurred. The couple's child was in the home at the time, but did not witness the altercation, but was able to communicate to the officer that he heard the screams, which woke him up out of his sleep. Your Honor, the state is recommending a $4,000 surety bond, no further contact with Ms. Satoria Jones, a stay away from that incident location at 2479 Abner Terrace, no alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, the state does believe the defendant does have a risk of reoffending, as the defendant has an open case in Fulton County for battery against another woman that he shares a child with, Your Honor. And the state does believe this is a situation of witness intimidation, because the victim could not communicate to the officers what actions the defendant committed that resulted in those severe bruises to her face and neck areas, but only told the officer that the defendant bit her finger. We believe that she may be in fear of the defendant and will sway away from participating in prosecution process. In addition to, Your Honor, you've heard from pretrial that he does have those previous battery convictions out of Cobb from 2017, and as well as previous FTAs. So we are concerned that he is also a flight risk. Nothing further.
All right, at this time, I'm going to sound for the victim, last name Jones. If you are present on the Zoom conference and would like to make a statement, this is your opportunity to do so. Ms. Jones, if you are present, this is your opportunity. All right, hearing none. Ms. Kim?
Yes, Your Honor. He actually said he does not know this lady that much. Unlike the way he told me was, this was some kind of big party, and he went there, and Satoria Jones was completely drunken, and she was attacking him. So she was the primary aggressor, and he was basically defending himself, try to stay away from her violence. And he says he does not live with her, and he does not have child with her either. And he is 35 years old, and he has been here in Georgia from 2003, and he has 4 daughters and 2 sons, and they're all minors, and he's married right now, and he has a father and 4 siblings here in Georgia. So all his family is here. He's not a flight risk, and he has been working as a subcontractor for different clubs, and he's been doing that for about 7 years. And he graduated from high school successfully, and he also went to Atlanta Institute University, and he studied international business and criminal justice there. And he would like to request for signature bond. And yet, if Your Honor is not inclined to give him a signature bond, we would like to request for the maximum $1,000 surety bond, Your Honor.
All right, thank you, Ms. Kim. At this time, the defendant's going to receive a $2,500 surety bond. He is to have no weapons, drugs, or alcohol. He is to have no further contact with the victim, last name Jones, and he is to stay away from the address at 2479 Abner Terrace, Unit 227 in Atlanta. Is there anything further from either party?
No, Your Honor.
Nothing further, Your Honor.
All right, best of luck to you, sir. We can move to the next position.
Saunders. Next, we have position 15, Saunders.
Is there any way we could do position 13? No?
We're gonna do them next, Judge.
Okay. I'm just trying to, I see private counsel on the screen. All right. Are you Malcolm Saunders?
Yes, ma'am.
Okay, Mr. Saunders, your case is 22 CR 001667E, in which you're charged with fair evasion with an offense date of March the 22nd. I've advised you of your constitutional rights. Do you understand them?
Yes, ma'am.
Do you object to the video today?
No, ma'am.
Do you object to your attorney appearing by video?
No.
All right. Mr. Howard?
28 total.
Okay.
Just
Most
3 out
is
of 0.
interested in something violent and stuff that's open.
Last arrest was March 2021, Bibb County, ag assault, simple battery. That was 2 counts of ag. Appears to be open. 2019 disorderly conduct conviction. 2018 battery DV conviction. 2017 battery conviction. 2016 was dismissed. That's it.
All right, thank you. Ms. Duncan.
Yes, Your Honor, this incident took place on March 22nd, 2022 at around 3:39 p.m. At 80 Anderson Avenue, which is the Westlake MARTA station. This defendant was observed by MARTA police pushing through the fare gate without paying the fare required to enter MARTA. Given the nature of this offense, the state is recommending a bond in the amount of $2,000 signature and a stay away from the Westlake MARTA station.
Okay, you're recommending a signature bond. All right, Ms. Kim.
Yes, we have no objection, Your Honor. However, we have only one concern about the stay away. He works from, he has to take MARTA every day from Westlake to 5 Point, and then he changes the lane to go to Bucket area. That's where he works as a full-time restaurant. And this is completely misunderstanding, Your Honor. He was basically, he has a like MARTA Breeze card that kind of has, he can use it continuously. And this time, the balance was $2. So he automatically thought he had enough balance, and he was going through that, and then it didn't work. So he was actually approaching the officers to kind of like see if he can get 50 cents more. However, automatically, officers assumed he was some kind of like criminal trespass person, and they arrested him for 50 cents. He already spent 8 hours in jail for 50 cents, Your Honor. And right. He has to go to work, so please, he has to go to stay away only except when he goes to work, please, Your Honor.
All right, that's a reasonable compromise, Ms. Kim. At this time, the defendant is going to receive a $2,000 signature bond through the jail. He can use the Westlake MARTA station only if he's traveling to and from work. Otherwise, he must completely stay away from the Westlake MARTA station. I am also going to require no alcohol, drugs, or weapons as a condition of his bond.
Thank you, Your Honor.
All right, best of luck to you, Mr. Saunders.
All right. Position 18 next, or was it 13?
13, please. I believe his attorney, I see a Ben Sessions on the screen.
Yes, Your Honor, it's Daniel Osman.
Okay.
And Your Honor,
Daniel Osman.
My apologies, Your Honor. I heard position 18. Just wanted to announce Attorney Terrell Thomas here for position 18, Cameron Snelling, at your convenience.
Okay, so if we could do 13 and then 18, that would be ideal. All right, Mr. Sessions, you want to just enter? Well, let me give him his rights. Hold 1 second. Good afternoon. Are you Daniel Osman?
Yes.
Mr. Osman, your case is 22 CR 001663J, in which you're charged with battery, family violence, cruelty to children in the 3rd degree, 4 counts, with an offense date of March the 21st of 2022. I've advised you of your constitutional rights. Do you understand those rights?
Yes.
Do you object to a video hearing today?
No, I do not.
Do you, counsel, will you please enter your appearance very briefly?
Yes, Your Honor. I'm Ben Sessions, bar number 141280. I'll file a formal entry of appearance after I get back to the office, Your Honor.
All right. Do you object to your attorney, Mr. Ben Sessions, assisting you by this video conference?
No.
Okay, thank you. All right, at this time, Mr. Howard, first arrest. All right, so we'll go straight to Ms. Duncan.
Yes, Your Honor, as you stated, this incident took place almost not even 2 days ago on March 21st, 2022 at 281 King Road at around 9 p.m. The victim in this case is Carmel Osman, and there are 4 children involved. We are not certain on the ages, but we'll identify them by initials due to the fact that they're most likely minor. In this case, Your Honor, the defendant grabbed Mrs. Osman her phone away from her, threw her to the ground, and put his foot on her chest. Because of the actions of the defendant in this case, the victim sustained visible lacerations on her nose and her elbow. Officers deemed that the defendant in this case was in fact the primary aggressor. All events have been stated to have taken place in front of the 4 minor children. For the record, M.O., H.O., E.O., and A.O. Given that this is the defendant's first offense, however, we're concerned about the violent nature and the course of actions taking place. He did, in fact, put his foot on her chest. That is very dangerous. Therefore, the state is requesting a $7,000 total surety bond. That's $3,000 for the battery, family violence, and $1,000 for each count of cruelty to children in the 3rd degree, as well as we have not been able to make successful contact with the victim. So in the interest of her safety and the safety of the children involved, we would request no further contact with Mrs. Osmond and third-party contact for the children. Stay away from the incident location, 1-day anger awareness, and no alcohol, drugs, or weapons.
What is the stay away address, Ms. Duncan?
281 King Road.
All right, thank you. I didn't catch that earlier. Before I go to you, Mr. Sessions, at this time, I'm going to sound for Ms. Osmond. Ms. Osmond, if you are present on this Zoom conference and would like to make a statement, this is your opportunity to be heard. You would just need to turn on your audio and your video such that we can hear from you at this time. And again, I am sounding for a Miss Osmond at this time. All right, hearing none, Mr. Sessions.
Yes, Your Honor. Mr. Osmond is 43 years old, no prior criminal history whatsoever. That's Ms. Osmond is his wife. They reside at that address at 281 King Drive with their 4 children. Those children, Your Honor, are 13, 11, 9, and 5. I'm here because Ms. Osmond has engaged me on behalf of her husband. She does want him to be released. She does want there to be some sort of intervention that's involved here. And Your Honor, what I'm proposing is that as a condition of the bond, that Mr. Osmond be permitted to maintain the residence with no violent contact with any of the family members, obviously, and that he be required to undergo a 24-week family violence intervention program as a condition of the bond. The no alcohol, no drugs, no firearms of any sort. Obviously, I think are reasonable conditions given what the allegations are here. I won't go into litigating those here with Your Honor. Just ask that he be released through pretrial services that will be able to supervise those conditions, Your Honor, particularly the family violence intervention program, Your Honor.
And Mr. Sessions, you were recommending how long of a intervention program? You said 24 weeks?
Yes, Your Honor. And I believe that is the longest period of family violence intervention program that I'm aware of.
That's very long. Mr. Sessions, this is where the court stands without a statement from Ms. Osmond that she wants to have him return home and wants to have contact with him. I don't feel comfortable ruling that at this time. If you want to drop off of this call and have her, give her this Zoom link and give her the opportunity to appear and speak, I will consider it, but I'm not going to do it without a statement before the court today.
I tell you, Your
All
Honor,
right.
I actually don't think it will be bad for us to have a no contact for a period of time, just for a cooling off. And I can revisit on a modification with the state court after a couple of weeks, Your Honor.
All right, this is what I'm going to do. Mr. Osmond is going to receive, I'm sorry, let me, before I rule, anything further from you, Ms. Duncan, or you, Mr. Osmond, Mr. Session, before I enter my decision?
No, Your Honor, thank you.
We just concur with the court's concern for the safety of the victim and the children in this case, Your Honor. Nothing
All right.
further.
All right. At this time, Mr. Osmond is going to receive a $10,000 signature bond through pretrial services. He is to take 24 weeks seems a bit much for me. So at this point, I'm going to issue a 6-week anger management course that he should take at this time. He is to have no further contact with the victim, last name Osmond. He needs to arrange transport of his children through a third party at this time. As Mr. Sessions indicated, he will seek further modification after a cooling off period. He is also to stay away from that address on Kings Road. He can return one time with a member of law enforcement to get any of the items that remain in his possession. And he is to have no alcohol, drugs, or weapons as a condition of this bond at this time.
Judge,
All
will
right,
you
is
break
it-
down that bond, please?
Yes, ma'am. I apologize, Ms. Holly. On the battery family violence, it's going to be the $6,000 signature bond, and then it should turn out to be $1,000 for each cruelty charge, if my math is correct. All right. Is
Would
there
it be
anything?
possible for that bond order to be?
I believe that might be possible. I will ask Ms. Holly. Is that possible, Ms. Holly?
If it could be what, sir?
If it could be
He's
emailed
asking for
over
a
to
copy
me,
of
if
the
I put it
bond
in my
order
chat.
be emailed to him.
Yes, if you will put your email address in the chat, and once the judge has signed it, I will gladly do so.
Thank you so much,
Ms.
Ms. Bridgewater.
Thank you so much. All right, best of luck to you, Mr. Osmond. Can we now move to position 18, I believe it was? All right, are you Cameron Snelling?
Yes.
Mr. Snelling, your case is 22 CR 0016548, and what you're charged with battery family violence with an offense date of March the 22nd of 2022. I've advised you of your constitutional rights. Do you understand them?
Yes.
Do you object to the video hearing today?
No.
Counsel, will you please enter your appearance at this time?
Yes, Your Honor. This is Attorney Terrell Thomas, bar number 758-106 for Mr. Cameron Snelling.
All right. Thank you. Do you object to your attorney assisting you by video?
No.
Mr. Snelling, thank
No.
you. Mr. Howard, second arrest, correct?
Yes.
All right, just confirming. Thank you. We'll go straight to Miss. Yes, Mr. Howard.
I was gonna put on the record. Last arrest, 2021 DUI.
Okay, thank you. Ms. Webb, then we'll be with you, Mr. Thomas. Ms. Webb?
Yes, Your Honor. This incident took place on yesterday at 3699 Lyddix Road Northeast, where Atlanta Police Department responded to a domestic dispute call and were met with the defendant's child's mother, Miss Blake Stewart. That's Blake, Blake, Stewart, Stewart. The child's mother informed the officer that the defendant put his quote unquote hands on her during an altercation regarding their 6-year-old son. The son reported to the mother when she picked him up that he saw the father in bed with someone else, and she confronted the defendant about this behavior. The defendant informed the officer that he told Miss Blake that he did not want to be in a relationship with her, and a verbal altercation ensued. And during that argument, the defendant struck Miss Stewart informed the officer that during the argument, the defendant struck her with his fist, which resulted in her sustaining several scratch marks on her arm. Your Honor, the state is recommending a $2,500 surety bond, no further contact with Miss Blake Stewart, a stay away from that incident location, no alcohol, drugs, or weapons, 1-day anger awareness, and third-party contact with the party's minor child. Your Honor, our office is still conducting a full investigation to determine the full facts as what occurred between the parties, but we are concerned with the risk of reoffending and witness intimidation if the parties are not able to resolve the underlying issues regarding ending the relationship and establishing co-parenting times amicably and without state intervention. Nothing further.
All right, thank you, Ms. Webb. At this time, before I go to Mr. Thomas, I'm going to sound for the victim, last name Stewart. Ms. Stewart,
Yes, Your
if you would
Honor.
like to be heard, if you would like to make, you're not required to make a statement. Would you like to make a statement at this time?
I would just say that I'm
Wait,
not in fear.
Before you do so, I need you to raise your right hand. I'm just first asking if you wanted to make a statement. So you do. All right. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. What would you like to tell the court today?
I would just say that I am not in fear of my life. I am not opposed to Cameron having a signature bond. I'm also not opposed to just having a no violent contact. We do co-parent our child together. We day-to-day action with our child. So I'm not opposed to a signature bond or no violent contact.
All right. Thank you so much. Mr. Thomas?
Yes, Your Honor. Good afternoon. First off, huge apologies for my appearance. This was requested of me at the last minute. Fortunately, I had a blazer in my back seat. So wanted to apologize to the court for that.
We've all been there, Mr. Thomas. We have all been there. Please proceed.
So I am here solely just for first appearance purposes. But for Mr. Cameron Snelling, he resides locally near the incident location, Maple Street in the Buckhead area where the incident took place. His son, Chase, also resides with him there, both with him and his mother at a separate residence. Mr. Snelling has a master's degree and is currently employed locally as an accountant at State Street Bank in Buckhead. He has no criminal history. That one prior arrest, that DUI, was dismissed. There also is no prior conflict history between Mr. Snelling and Miss Jasmine. They co-parent pretty well with no issues. He's an active and present father. He's not just a father. He's an active and present father to his son, Chase. Takes him to school and his extracurriculars as well. As you heard Miss Jasmine say, she is not in fear at all. And they co-parent just fine and would like to continue that successful co-parenting for the sake of Chase. And so with that, if the court has any more questions for Miss Jasmine, who was on the call, we would respectfully ask for a signature bond for Mr. Snelling and a no violent contact to not interfere with the parenting.
All right, thank you. At this time, Mr. Snelling is going to receive a $5,000 signature bond through pretrial services. He is to have no further violent contact with the victim, last name Stewart. He is to complete a one-day anger awareness course, and he is to have no weapons, drugs, or alcohol as the condition of this bond. Is there anything further from either party?
Nothing further, Your Honor. That concludes my business.
Yes, you can be excused, Mr. Thomas. Have a great afternoon. Take care.
You too,
All
Judge.
right. All right. Best of luck to you, Mrs. Snelling. That will conclude your case. Who do we have next?
Position 3, Mr. Chisholm.
Okay, thank you. All right, good afternoon, Mr. Chisholm. Your case is 22 CR 001665Y, in which you're charged with battery family violence with an offense date of March the 22nd of 2022. I've advised you of your constitutional rights. Do you understand? Do you understand those rights? Do you object to me conducting this by video today?
No, ma'am.
And do you object to your attorney? I believe Mr. Ford. Do you object to Mr. Ford appearing by video?
No, ma'am.
All right, thank you. Mr. Howard, first arrest? No, not first. Mr. Howard, the history, please.
Fourth arrest. 2016 probation violation. Possession of marijuana. Came off a 2016 conviction. 2013 simple battery on officer conviction. That's it.
Okay. Thank you. All right, Ms. Webb.
Yes, Your Honor. This incident took place on March the 21st, where Atlanta Police Department responded to a domestic dispute call and were met with Mr. Kevin Patterson. That's Kevin common spelling, Patterson common spelling, who informed the officer that the defendant came to the location to retrieve his things because he recently filed a temporary restraining order against him. When the defendant arrived, there was a locksmith at that location changing the locks on the home, and the defendant became irate and an argument ensued. After that point, during that argument, the defendant slapped Mr. Patterson's phone out of his hand and slapped him in the face, causing lacerations and abrasions to Mr. Patterson's face. Your Honor, for those reasons, the state is recommending a $3,000 surety, a stay away from the incident location at 294 Deering Road, Atlanta, no further contact with Mr. Kevin Patterson, no alcohol, drugs, or weapons, and one-day anger awareness. Your Honor, our office did make contact with Mr. Patterson, and he informed us that he did file for that restraining order against the defendant and that he does not want to have any contact and does not want him to return to that location to retrieve his items, but is willing to have his items sent to him through a third party. We did advise him that the proper procedure is for the defendant to be able to go to that location with the law enforcement escort, but he advised that he does not feel safe in his presence, even in the presence of a law enforcement officer, Your Honor. So for those reasons, we are concerned with witness intimidation and a risk of reoffending. As you've heard from pretrial, he does have that simple battery conviction from Chatham County from 2013. Nothing further.
All right, thank you, Mr. Well, before I go to Mr. Ford, I'm gonna sound for the victim, last name Patterson. Mr. Patterson, if you would like to make a statement, this is your opportunity to do so. You're not required to, however. Would you like to make a statement?
No, Your Honor.
All right, thank you, Mr. Patterson. All right, Mr. Ford.
Thank you, Your Honor. We don't believe that my client is at risk of reoffending. There was the probation violation was in 16, the offense was 16, the other situation was 2013. We're talking almost a 10-year offense. My client is a high school graduate. He is attending college. He's at 8 months of college. He works for Capital One Security. He's been there for 4 months. At this point, he does have a valid driver's license. He is looking for permanent housing. He knows that he's not supposed to return to the 294 Deering Road. He would like to have a one-time permission with an officer to receive his items. He does have great community support. I have telephone number for his mother. And also he gave me a number for a close friend. He does not have any current or recent violent crimes. As I mentioned before, he's not at risk of flight. He's been secure here in Georgia for over 6 years and has a secure job, so he's not going anywhere. Your Honor, it was total misunderstanding. He felt he was given the opportunity to come back and retrieve his items. And so at this point, we're asking for some type of unsecured judicial release or a signature bond at this time, Your Honor.
All right, thank you. At this time, Mr. Chisholm is going to receive a $6,000 signature bond through pretrial services. He is to complete a one-day anger awareness course. He must stay away from the address on Deering Road. He can return one time with a member of law enforcement to get his items. He is to have no further contact with the victim, last name Patterson, and he is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing further, Your Honor.
All right, best of luck to you too. I'm sorry?
What was the contact?
No contact, no further contact. None whatsoever. You understand that, Mr. Chisholm? No contact whatsoever. I direct you to not even look at Mr. Patterson when you're going to get your items with law enforcement. All right, that will conclude your case. Best of luck to you, sir. We can move to the next position.
Next, we have position 8, Mr. Jeter.
Okay. All right, good afternoon, sir. Your case.
What was that? What was that position number, Your Honor? I missed it.
8. We're on position 8. I believe your name is DeCavion Jeter, or is it Jeter? All right, Mr. Jeter, your case is 22 CR 001650G, in which you're charged with 1 count of battery, family violence, and 1 count of cruelty to children in the 3rd degree, with an offense date of January of 2020. I've advised you of your rights. Do you understand those rights?
Yes, ma'am.
And do you object to the video hearing or to Mr. Ford helping you by video today?
No, ma'am.
All right, thank you so much. Mr. Howard, I know it's the second. Please put on the record what those were.
Last arrest 2018, battery DV, simple battery, family violence. They were dismissed out of Clayton County.
Thank you. All right, Ms. Webb.
Yes, Your Honor. This incident took place on January the 25th, 2020 at 6791 Darby Avenue, South Fulton, Georgia, where the South Fulton Police Department responded to a domestic dispute call and were met with Ms. Corey Robertson. That's Corey, C-O-R-I-E, Robertson or Robertson, R-O-B-E-R-T-O-T-S-O-N, excuse me. She informed the officer that she and the defendant had a verbal altercation that turned physical after the defendant confronted her about a situation concerning a coworker at her job. The two worked together at the time at the 1000 Logistics in Fairburn, Georgia, and were residing together as well. She informed that officer that when they arrived home, the defendant told her to never have another man to confront him and that she looked guilty. Ms. Robertson reassured him that nothing was going on and that with that coworker and that he needed to calm down so that they could talk, and she did not want her 6-year-old daughter, who was present in the home at the time, to hear them arguing. The defendant told her, "I don't beep, B word," and her daughter exited the room as they were arguing, and He continued to argue with the mother throughout that evening, Your Honor, and verbally assault her in the presence of the child. Things later turned physical after she closed herself into a bathroom and went into the bedroom to grab her shoes so that she could leave to have some space. When she entered the room, the defendant told her that if she touched him, he would knock her out. The defendant would allow her to grab those shoes that were in that area. So when she lightly pushed him out of the way, that is when the defendant slapped her in the face, causing bruising. She grabbed her daughter and hid in the bathroom until it was time to take her child to school. And when she returned from taking her daughter to school, the defendant was still present at the scene. And once he left, that is when she called for the police. Your Honor, the state is recommending a $3,000 surety for the battery charge, $1,500 surety for cruelty to children, totaling $4,500 surety. No further contact with Ms. Corey Robertson and minor child. A stay away from that incident location at 6791 Darby Avenue. No alcohol, drugs, or weapons, and 1 day anger awareness, Your Honor. We are concerned with risk of reoffending and witness intimidation, Your Honor. Ms. Robertson did tell the officer that she waited to call the police until it was gone because she was afraid of the defendant and she did not want her daughter to see everything that was truly going on at the time. Nothing further.
I do want to confirm the offense date is January 22nd of 2020. Do I have that correct? Or no, that's not the correct incident date?
Your Honor, you are correct. Excuse me.
Okay. I just wanted to verify that. All right. Thank you. All right, Mr. Ford.
Thank you, Your Honor. My client has pretty much no criminal history, Your Honor. He is not at risk of reoffending. He's 28 years old. He's a high school graduate. He's always been gainfully employed. He is moving away from the GoTRG warehouse and moving on to the Walmart warehouse where he's supposed to start tomorrow, Your Honor. He's been a lifetime resident of Georgia, so at this point, Your Honor, he's not at risk of flight. He has plenty of community support. He will be living with his mother, who I have her telephone number and address, so there will be no issue with any type of stay away. He has no problem with no further contact at this time. He wants to get back. He wants to be released on the recommended signature bond or unsecured judicial release that pretrial services have recommended, so he can go and receive the job at Walmart warehouse where he's going to get a significant increase in pay, Your Honor. So at this point, and he has a valid driver's license. Mr. Jeter, this is for him, this is like he denies some of the issues, so he'll deal with that at a later time. And at this point, Your Honor, we're recommending that he receive a signature bond or some type of unsecured judicial release.
All right, thank you. I'm going to sound for the victim. Is it Robertson or Robertson? I'm sorry, I wasn't sure. If you are present on the screen, this is your opportunity to make a statement. If Miss Corey Robertson or perhaps Robertson is present, this is your opportunity to speak. All right, hearing none. Anything further from either party at this time?
Your Honor, I did check that police report and the date on the report states January 25th, 2020. So I just wanted to clarify the record. Okay,
it is still some time ago, so correct?
Yes, Your Honor.
Okay, at this time, Mr. Jeter is going to receive an $8,000 signature bond through pretrial services. That'll be $4,000 for the cruelty and $4,000 for the battery. He is to have no further contact with the victim, last name Robertson, I believe, and he is to stay away from that address on Darby Avenue. If he has any items there, he can return one time with a member of law enforcement to get any items. He is also to take a 1 day anger awareness course. He is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further?
Nothing further from the state, Your Honor.
Nothing further, Your Honor.
All right, best of luck to you, sir. We can move to the next position. Who do we have next?
Judge, that was a good bond, correct?
No, signature through pretrial services.
Next, we have Mr. Sutton, position 19.
All right, good afternoon, Mr. Sutton. Your case is 22 CR 001655E, in which you're charged with willful obstruction of a law enforcement officer, a seatbelt violation, failure to maintain insurance, and driving on an expired tag, each with offense dates of March 22nd of 2021. Is that correct? We'll have to verify that, of 2021. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney, as I've explained previously. Do you object to this video hearing?
No, ma'am.
You object to your attorney helping you by video?
No, ma'am.
All right, thank you, Mr. Howard. I think we went through this, but what is the history, please, for the record?
What's the rest? Last arrest was 2006. Criminal trespass, dead docket. 05 Central Battery, family violence, arrest. And a 99 battery / Central Battery, family violence, dead docket.
Okay, thank you. Ms. Duncan.
Yes, Your Honor. The incidents related to these accusations took place on March 22nd, 2021. Let me
Okay.
check. Let me make
I
sure.
just wanted to verify that was the day. It's like a year ago. So
Okay.
close that I wanted to make sure it is last year.
Let me make sure, Your Honor. My apologies.
Yes, Your Honor.
We're on Sutton, correct?
Correct, position 19, Randolph Sutton. It's all right if you don't see it, Ms. Duncan. We'll just presume that is correct, that it was on that 21st. You can proceed.
Okay. In this incident, Your Honor, officers were stationary near Campbellton Road in Fairburn, and they observed a vehicle, which was a Toyota Camry. A person in the vehicle the person driving the vehicle, my apologies, did not have on a seatbelt. So the officer activated their lights and emergency equipment and conducted a traffic stop. Upon conducting the traffic stop, the officer spoke with the defendant in this case, who was the driver of the vehicle, and informed the defendant for the reason of the stop. At that time, the officer had some concerns because they smelt an odor of marijuana emitting from the vehicle. However, the defendant stated that he didn't have any substances in the vehicle, but officers also asked at the time if the vehicle was registered. The defendant said he didn't have any substances, and he admitted that the vehicle was not registered. And the defendant at that time could also not produce proof of insurance when asked. Officers further inquired after the defendant was out of the vehicle and informed him to stay out of the vehicle. And when they went back to their car to check on the information that was given to them, the defendant in this case ran back to the vehicle after being told not to, jumped in the vehicle and proceeded to try and speed away to prevent further investigation. In addition, the traffic stop was for no seatbelt and also no tag display. When officers came in contact, no insurance was provided, and he could not produce any temporary tags or temporary registrations or transfer applications for registration due to the facts and circumstances surrounding the incidents alleged in this incident. The state is requesting, in addition to my apologies, we looked at the driving record. There are about 3 speeding tickets, 1 improper turn, and 2 excessive school absence citations. So we're requesting a $4,000 surety bond. That's $2,000 surety on each charge. No alcohol, drugs, and weapons, and no driving unless properly licensed, registered, and insured.
All right, thank you. All right, Ms. Kim.
Yes, Your Honor. Mr. Sutton is actually 41 years old, and he claims that he has an insurance, just he didn't have it with him at that time to be produced. However, there was effective insurance, and he has been here in Georgia for all his life, 41 years. He has 5 children here in Georgia, 17, 7, 2. So most of them are minors. And even though he is not married, he has, all of them are with one, all the children have one mother. And he has mom and dad here and siblings here in Georgia. I don't think he's going to run away. Only thing is, though, he does not have a job at this point. He has been unemployed for the last 2 or 3 years. Actually, he became daddy at home, stay-home daddy to watch his children right now. And he has 10th grade education. And we would like to request for signature bond, considering the fact that all his previous charges happened 10 or 15 years ago. Those are very remote, and I think this is just a matter of like producing the documents for him to kind of organize and take care of the matters. So we would like to request for signature bond. Thank you.
Right, thank you. And Ms. Duncan, I wanted to clarify one point. You're asking for no driving?
Unless appropriately licensed, insured, and registered.
Okay.
And if not, no driving.
All right. I think that is a fair condition. At this time, Mr. Sutton is going to receive a $4,000 signature bond through the jail. He is to have no driving unless appropriately licensed and insured as requested by the state. He is to have no alcohol, drugs, or weapons. And I believe I've addressed all special conditions. It will be $1,000 for each charge. Is there anything further from either party?
2,000 or 1,000, Your Honor.
It should be it's 4 charges and it's a $4,000 signature bond.
Okay.
So that should be $1,000 for each charge through the
And that's
jail.
through the jail?
Yes, ma'am.
Thank you.
All right. Is there anything further?
Nothing further.
All right. Best of luck to you, Mr. Sutton. We can move to the next position.
Position 7, Mr. Favors.
All right, good afternoon, Mr. Favors. Your case is 22 CR 001656D, in which you're charged with criminal trespass with an offense date of August the 1st of 2020. I've advised you of your constitutional rights. Do you object to the video hearing today?
No, ma'am.
Do you object to your attorney, Mr. Ford, assisting you by video?
No, ma'am.
All right, thank you so much. Ms. Webb.
Yes, Your Honor. In this case, the state is recommending a $5,000 surety with a stay away at the incident location, 2500 Center Street, Atlanta, with no alcohol, drugs, or weapons as a condition. Your Honor, this is a case of a repeat offender. On August the 10th of 2021, Atlanta Police Department responded to a trespass call. The officers were familiar with the defendant because the defendant was issued several previous stay away warnings by APD from that same incident location, Your Honor. The officer who actually arrested the defendant in this particular case cited in the report that the defendant has been issued and arrested for trespass for selling drugs or committing drug transactions at that location. In addition to this, Your Honor, the defendant is currently being held on additional felony drug possession charges from an incident that took place on yesterday at that incident location, Your Honor. And we do believe that this is a case of risk of reoffending and a flight risk, as the defendant was arrested on February 2021 at the same incident location for selling marijuana at the property, and where he was found guilty for criminal trespass. Same facts from July the 4th, 2020, where the defendant was arrested for selling marijuana on that property and found guilty for criminal trespass. This is a cycle of rinse and repeat, and the defendant refuses to abide by this honorable court's orders to stay away from that property and gets out and reoffends again at that same location, Your Honor. So for those reasons, the state is recommending the $5,000 surety bond today. Nothing further.
Tell me, do you know what type of business? Is that a business or is it a home? What is that?
It's cited as Preservation Partners as the name of the owners of that property, Your Honor. When I looked it up, it looks, I couldn't quite tell because from the Google images, Your Honor.
And do you have his full history, Ms. Webb, that you could give me?
Yes, Your Honor, if you give me 1 second. He has an FTA from Fulton from 2022 from an earlier case, Your Honor. 1 second. My computer just.
It's okay, take your time. I need to know. I'm most interested in violence, of course, and FTAs.
Excuse me, can I say something?
Mr. Favors, I advise you not to say anything to me. The best thing to do is allow your attorney to represent you, because anything you say can and will be used against you, all right?
All right.
Yes, Your Honor. So I have from 2008 in Fulton. It's an extensive one, but 2008 in Fulton, the defendant does have a guilty conviction for simple battery, where he was placed on, looks like, probation for 12 months. He also FTA'd on those additional charges out of Atlanta in March of 2010. It looks like he has another simple battery arrest from 2010, but it looks like the statute of limitations ran. He also has a battery conviction from 2010 out of Fulton County, in addition to an obstruction of conviction, Your Honor. Let me go. It's several probation violations. He has another burglary conviction from 2011 out of Fulton. Let's see here. Several probation violations out of Atlanta. Let's see. I'm going down. He has another 2017 battery arrest with substantial harm out of Atlanta, where the statute ran on that as well. He has another FTA out of Atlanta from 2018 on several charges, including abandonment of dangerous drugs and obstruction.
Okay, I think that's good. Thank you, Ms. Webb. I think I have a clear picture. I appreciate you doing that. Mr. Ford?
Thank you, Your Honor. First of all, Your Honor, I think the ASG Webb did mention that this is an August 1st, 2021 case. This is an August 1st, 2020 case.
Okay.
And at this point, there are no drug charges before us today, Your Honor. Only criminal trespass. So I object to the mention of the drug charges or incidents that took place. At this point, my client is 33 years old. He does have a valid driver's. He owns a vehicle that he allows someone else to use because she is transporting. He has 4 children. He has a 4, 5, and 6-year-old and 10-year-old. And so at this point, he's been a lifetime resident of Georgia. So he's not at risk of flight. And he has tremendous community support. He has his father, mother, sisters, and brothers who all stay here in Georgia. And he also has a stable address at this time, Your Honor. I would ask that if not a signature bond, Your Honor, some very low bond, such as $1,000 surety for Mr. Favors at this time.
All right, thank you. At this time, Mr. Favors is going to receive a $1,500 surety bond, and he is to stay away from that incident location. He is to have no weapons, drugs, or alcohol as a condition of his bond. Is there anything further from either party?
Nothing further, Your Honor.
Nothing further, Your Honor.
All right, best of luck to you, Mr. Favors. The best thing for you to do, I see you have concerns. The best thing for you to do is to reach out to Mr. Ford with your questions, okay? I do not want you to say something inadvertently the state may use against you, okay?
Now, it was just, I was trying to figure out where was the incident. I don't even know where the incident was.
Okay, Mr. Ford, perhaps you'll give him a call after this proceeding, all right?
All right, thank you, Your Honor.
All right, thank you. Who do we have next?
Mr. Curtis. Michael Curtis.
Okay.
He is.
We're on position 6, Michael Kevin Curtis. Mr. Curtis, your case is 22 CR 001662A, in which you're charged with 1 count driving hit and run, 1 count of driving while license is suspended, and 1 count of driving improper or erratic lane change, each with offense dates of May 6th of 2020. I've advised you of your rights. Do you understand those constitutional rights?
You sure these are my charges?
Those are the charges against you. Do you object to, do you understand your rights? Let's go with that first.
I understand my rights, but I object to these charges.
Okay, I understand. And don't say too much. I don't want you to say something by mistake. Those are the charges.
Hold on.
You are Michael Curtis, correct?
Yes, ma'am.
Okay. Do you object to this video hearing?
Yes, ma'am.
You object to the video? You don't want me to speak to you on video today?
I want to give you a handle, but I'm trying to figure out where these charges come from. That's not what I'm incarcerated for.
Okay, I don't want you to say too much. Okay, but as we go forth, I think you'll hear what's happening. Can your attorney assist you by video today? He can, thank you. All right, Mr. Howard.
27 total. Last arrest was 2019, harassing phone calls. 2019 probation violation. 2016 failure to appear. Possession of a firearm by convicted felon. Felony theft by receiving. Not prosecuted was the disposition. 2015 FTAs, ag battery, ag assault. Possession of a firearm by convicted felon. Got a suspended license, given false name. He pled NOLO 2 in 2015. Possession of a firearm by convicted felon, conviction from 2016. Got a suspended license, not presented to grand jury 2013. I counted about 3 parole violations from 2010.
Okay, I think that's good. Thank you, Mr. Howard. Ms. Webb.
Yes, Your Honor. This incident took place on May the 6th, 2020, where the Atlanta Police Department responded to an accident call on I-20 eastbound at Joseph Laurie Boulevard exit, and they were met by the victim, Mr. or Miss Ibiza, that's spelled E-B-E-S-S-A, Ahmed, A-H-M-E-D, who informed the officer that the defendant struck the passenger side of his vehicle after improperly moving into his lane while traveling eastbound on I-20 near that exit, which caused damages to the vehicle. The victim informed the officer that the defendant exited his vehicle and took off running. The victim was able to get the vehicle information as it was left at the scene, and that vehicle was returned as a car owned by Enterprise Rentals. After an investigation conducted by that officer, the officer was able to make contact with the defendant's ex-girlfriend who actually rented that vehicle. She informed the officer that she received a call from Enterprise after the incident was reported, and she informed the officer that the defendant took off in that car in the middle of the night without her permission while she was sleeping. When she questioned the defendant about the case, he told her to tell the officer a fake name, which she refused, and that is when the defendant blocked her and stopped answering her phone calls. The officer was able to retrieve the defendant's information and found the defendant's license has been suspended since 2012. Your Honor, for those reasons, we are recommending a $1,500 surety for the hit and run, $1,000 surety for the erratic lane change, $1,000 surety for driving on a suspended license, totaling $3,500 surety with no alcohol, drugs, or weapons, and no driving as a condition. Your Honor, the state is concerned with risk of reoffending and flight risk, and that the defendant is a threat to the community. The defendant has an FTA on several traffic offenses dating back to 2015. The defendant's license has been suspended for failure to pay child support obligations and abide by child support obligations. And despite his notice of the suspension, he continues to drive. We do believe the defendant is a threat to the community because he commits offenses that could not only result in property damage, but also personal injury, and fails to fulfill his duty as a citizen to stop and assess these accidents at the scene and ensure that the other driver has his information. For those reasons, Your Honor, the state is making this recommendation today. Nothing further.
All right, thank you, Mr. Ford.
Thank you, Your Honor. Your Honor, my client is 35 years old. He's a high school graduate, and he's been working for NCW Fire Protection as an independent contractor for the past 7 years. So he's been gainfully employed for over 7 years. He's a lifetime resident of Georgia. So with his employment and the fact that he's been here in Georgia for his entire life, he is not at risk of flight, Your Honor. He does have community support. He did give me a number of a friend that lives here in Georgia. He has 3 children, Your Honor, that he's helping to financially support He has a girl that is 3, another girl that's 7, and a boy that is 16 years of age. He has a stable address and telephone number. Your Honor, I didn't hear any recent violent behavior from my client as far as any charges or convictions. We feel that $1,000, well, it would be a $500, and these are traffic offenses, Your Honor. These are not violent crimes. We feel that there should be a signature bond for the driving while license suspended, also for driving an erratic lane change, and a $500 surety bond, Your Honor, on the driving hit and run.
Okay, thank you. All right, is there anything further from either party before I issue my decision?
Nothing further.
Okay. Mr. Curtis is going to receive a $1,500 surety bond broken down as follows: $500 for the hit and run, $500 for the driving while license suspended or revoked, and $500 for the improper erratic lane change. His voice is getting dry. For a total of a $1,500 surety bond. He is to have no alcohol, drugs, or weapons, and no driving unless he has a valid license issued by the Georgia DDF. All right, is there anything further from either party?
Nothing further.
Nothing further, Your Honor.
All right, best of luck to you, Mr. Curtis. We can move to the next position.
Position 17, Mr. Smith.
All right, good afternoon, Mr. Smith. Your case is 22 CR 00165HJ, in which you're charged with simple battery and terroristic threats with an offense date of July the 5th of 2020. I've advised you of your rights. Do you understand them? All right, do you object to the video today?
No, ma'am.
Do you object to your attorney assisting you by video?
No, ma'am.
All right. Oh, I see it's Mr. Kelbo. All right. I did not realize that you were here. We would have tried to get to you earlier. Apologies, Mr. Kelbo. All right. Mr. Howard.
6 adult arrest. Last arrest was March 2020, battery DV. The case was DWAP. The victim was Janae Rome. Appears to have open case in the cab, 2018. What's the charges? Hold on, Judge. Got ag assault, possession of a firearm or a knife during the commission, criminal attempt to commit a felony, possession of cocaine, first offender from 08, driving without a valid license, dismissed, convictions for fleeing or attempt to elude, that was from 2018 out of DeKalb County. That's it. So he got the open 2019 case out of DeKalb.
Thank you. Ms. Duncan?
Yes, Your Honor. The incident in this case took place on July 5th, 2020. The incident location is 788 Magnolia Way. The victim in this case is Janae Rome. In this incident, officers were dispatched to the location listed, and upon arrival, they spoke with Ms. Rome, and she advised the officers that her boyfriend at the time, the defendant in this case, had come to her house and knocked on the door very loudly, like it was the police, and her underage daughter let him into the home. And once he came into the home, he couldn't get in properly because her underage daughter tried to let him in, and he pushed the door, damaging the door hinges. Upon entering the home, he made contact with Ms. Rome and began to hit her and pulled her hair out. Ms. Rome stated to officers that he then took her keys to her Dodge cars and without her permission attempted to flee the location, but arguments ensued. And during those arguments, it was recorded on Ms. Rome's phone. And when officers arrived, she showed officers the recordings of what had been said to her and of the things that were said during the altercation. The defendant was seen saying that the whole family would be in the ground playing with him, and that he would kill everybody. So because of the violent nature of this offense and the threats made to Ms. Rome and her family, and given the fact that this defendant does have prior violent offenses, as well as other violent cases with this same victim, we are requesting a bond in the amount of $5,000 total surety. That's $2,000 for the simple battery and $3,000 for the terroristic threats. No further contact with the victim in this case. Third party child contact. 1 day anger awareness, no alcohol, drugs, and weapons. If I'm not mistaken, Ms. Rome may be on the line if Your Honor would like to sound for her.
All right, I see Ms. Rome was on the line. Ms. Rome, if you would like to make a statement, you are not required to do so, but this is your opportunity to speak to the court. If you do want to make a statement, I would need you to turn on your camera and also to turn on your audio.
Yes, ma'am.
All right, so I need you to turn those on if you would like to speak.
I'm trying to turn on my video. It's not allowing me to for some reason.
Okay.
Let me try it again.
I believe it's coming. Something happened. You pressed something that might be effective.
Okay.
Okay,
it's saying it's not allowed.
Were you disabled by the host? Does it say that, Ms. Lewis? Are you able to
No,
see if
she may have a function on her phone, and she has to allow her phone to accept video calls or have access to the Zoom. So it's a function on her phone that she needs to go to a feature and change
okay,
it
Ms.
to
Rome,
allow.
you may hear, I think you've heard that information. There may be some
Okay,
settings or permissions that you didn't accept. In the meantime, please try to work that out. I'm going to go to you, Mr. Calval. Mr. Calval,
Okay, let me try.
Ms. Rome, please continue to try to make that happen, all right?
Okay.
Your Honor, I would not object if to the extent that that's an obstacle, I would not object to Ms. Rome testifying only verbally and with her camera not on if necessary. I've spoken to Ms. Rome, and I believe that she will tell Your Honor that she wants, she's not afraid of Mr. Smith, that she wants him to be released. I would point out to the court that as the Madam Prosecutor said, this incident occurred on July 5th of 2020. And since that time, Mr. Smith, they are no longer dating. They don't live together. They have no children together. And the case that was the prior case that involved Mr. Smith's prior case where Ms. Rome was the alleged victim, which is 21 CR 001506D. That case was accused in March of 2021. So it was accused almost a year after this incident date. The discovery was conducted. Mr. Smith attended arraignment, status conference, final plea, and had 2 jury trial dates. And at the second jury trial date, the case was dismissed for warrant of prosecution. And for some reason, he was never arrested on this case that arose from July 5th of 2020. And now this case was accused March 23rd, 2022. And hopefully Ms. Rome is able to speak, but what we're asking for a signature bond, Your Honor. This is an incident almost 2 years ago. And as I've said, he has been to court. Ms. Rome does not wish to prosecute. She's not afraid of him. She doesn't want to have no contact, so she would be fine with no violent contact, although they are not dating and don't live together and don't have children together, so they really have no need to have contact. So we would defer to Your Honor if you want to order no contact. Mr. Smith does not need to have contact with Ms. Rome to achieve any of his life goals. He's 33 years old. He had just recently stopped working at Fresh Express because he became sick with a bad case of the flu, and he is now healed and ready to return to work. He does not have much money because of that loss of job, and therefore we're asking for a signature bond.
All right, thank you, Mr. Kelbaugh. Ms. Rome, were you able to figure out the camera feature? We have to be able to identify you, unfortunately. So your voice.
I'm trying to send it to my coworker right now.
Okay.
And I'm trying to send the text message because it's still not allowing me. I went into my settings. I definitely would like to speak on the behalf.
All right.
So
Well,
I'm trying it right now.
Please try. Yeah, Ms. Duncan, were you going to make a statement?
Yes, I was, Your Honor. While we understand the sentiments articulated by Mr. Kilbaugh regarding the wishes of the victim, given the nature of the offenses, we do have a serious concern being that these threats and the actions were caught on videotape, and we have concern for the safety of the victim as well as accountability for the defendant in these cases. This particular warrant was dormant, and this was brought up now to address the timing discrepancy because the defendant was stopped on a traffic violation and it was discovered that he had a warrant for his arrest at that time. So that is now why this case is before us.
Did the state request any type of stay away? I don't believe so. Correct, Ms. Duncan?
Let me make sure, just so.
I don't believe I heard that. There probably is no need for a stay away based upon Ms. Kelbaugh's representation.
Yeah, no, I think we discovered that they don't live together. It was the first place that he came to and kicked the door in. So we just don't want him
You
to
didn't
have
request
contact.
that at this time.
Yeah, we just don't want him to have any contact with her.
Okay. Ms. Rome, I'm gonna delay my ruling. I'm gonna take notes so that we can come back to this. And we're gonna give Ms. Rome the opportunity to speak since she's making such an arduous effort to do so. So can we come to take someone else while Ms. Rome tries to figure this out, and we come back to Mr. Smith?
All right. Position 14, Mr. Robinson is next.
Okay. All right, good afternoon, Mr. Robinson. Your case is 22 CR 001661A, in which you're charged with terroristic threats with an offense date of November the 6th of 2019. I've advised you of your rights. Do you object to the video or to your attorney assisting you by video?
No, ma'am.
All right, thank you. Whose case is this for the state? Mr. Howard first. Mr. Howard, what is the history?
Who are we on?
14. Oh, okay. I'm sorry. We're gonna go back. Ms. Rome, were you able to make it work? Do I see you?
Yes.
Okay. I apologize. Let's go back to Mr. Smith. I know this is not the best order, but let's move this as quickly as we can. Ms. Smith, what was it that you would like to tell the court at this time?
So about the incident, the detective, he would not let it go.
Oh, wait, before you speak, I apologize. Ms. Rome, please raise your right hand.
Okay, yes.
Do you swear and affirm that the testimony you will give today is the truth to the best of your knowledge and under the penalty of perjury?
Yes.
Now, the main things that the court is concerned with is your whether or not you'd like to have some contact with Mr. Smith. You can get into some very limited facts, but please keep your statement as targeted towards your concerns for your safety, all right?
Okay. So my safety, I don't feel a threat to Mr. Smith. He never has been a threat to me. I am just as guilty as he is when we had a argument. When it comes to that video that the police is speaking of, he did not threaten me or my kids.
Okay.
He was talking about another incident at the time, and the police touched that.
Do you have,
I'm sorry?
And you don't have any children with Mr. Smith? Ms. Rome?
I'm sorry, it went out.
Do you have children with Mr. Smith?
Yes.
Okay, you all have one child together. How many children do you have together?
No, we don't have any kids together.
Okay, all
and
right.
we never lived together.
Okay. All right. Thank you, Ms. Rome.
If me and him have an argument, he's the type to walk away. He'll just leave. He never been a threat to me.
All right. Thank you, Ms. Rome. I appreciate that. All right. Is there anything further from either party as it pertains to Mr. Smith's case?
The state would just like to say at the time of incidents, the victim felt compelled to show officers that video, and we would just like to add for the record that the actions are consistent with the cycles of domestic abuse.
All right, thank you. Mr. Kelbaugh, any further comments?
No, Your Honor, I'd just like to reiterate the request for a signature bond, given Mr. Smith's limited financial means and the
All
age
right.
of the allegation.
Thank you. At this time, he's going to receive a split bond as well. For the simple battery, it's going to be a $1,500 surety bond. He is to have no further contact with the victim, last name Rome. He is to have no weapons, drugs, or alcohol as a condition of that bond. For count 2, he's going to receive a $3,000 signature bond through the jail with those same conditions. Is there anything further from either party? That total should be $4,500. $1,500 is good bond. Any further questions? If not, all right. Best of luck to you, Mr. Smith, and Mr. Kelbaugh. You can be excused. Have a great afternoon. Take care. All right. We're gonna go back to Mr. Robinson. Mr. Robinson, you didn't object to the video or to your attorney assisting you by video, so we'll go straight to Mr. Howard. Mr. Howard, position 14. What is the history, please?
27 total. I saw a 2010 battery conviction. He got several probation violations in his history. 2013, 2017 failure to appeal. He got entering auto convictions, battery, false statements. He had a burglary from 2010 that was dismissed. 2008 parole violation, 2 of those. That's all I saw as far as violence.
Okay.
Was it 2010?
Okay. Okay, thank you. Ms. Duncan.
Yes, Your Honor, the incidents in this case took place on November 6, 2019. The victim in this case is Danyata Thomas, Danyota, Thomas, common spelling. She is the parent of a same child with the defendant. In this case, Ms. Thomas walked into the Zone 1 police precinct and reported to officers at that time that she kept receiving text messages from her son's father, the defendant in this case. She said that she was constantly arguing with him over something or anything in general, and she showed officers her messages. Some of the messages were very explicit, and for concern of the court and listening ears, I will not sound those words, but he said that she was an unfit mother and that he didn't care about her. She couldn't take care of her children, that he would shoot her and shoot her car up if he ever caught her again. And at the time, she stated to the officers that she was afraid of what the defendant could do to her and her children. Given the nature and of the offenses alleged in this warrant and the victim's concern at the time for her safety and the safety of her children, given the defendant's criminal history and everything else that I've stated before, we are requesting a surety bond in the amount of $5,000. No further contact with the victim in this case, third-party child contact, one-day anger awareness, no alcohol, drugs, or weapons.
Okay, is the victim last name Thomas? If you would like to make a statement, this is your opportunity to do so. I believe that's the victim's last name. Is that correct, Ms. Duncan?
Yes, Thomas.
Thomas, if you are present on the screen and would like to be heard, this is your opportunity to do so. If so, I would just need you to turn on your camera. All right, I don't believe I see a Thomas on the screen, so we'll go to you, Ms. Kim.
And one moment, if I may interrupt, my apologies. We'd also like to stay away from wherever she lives. We know that this incident took place at the report was taken at the precinct, but we are not aware where she actually resides.
Okay, well, without an address, Ms. Duncan, if you don't know where she lives, I don't know. Let's hear from Ms. Kim first. Ms. Kim, we'll come back to that point. The state's request is noted.
Okay.
Ms. Kim.
Mr. Robinson is 33 years old, and he does not live with the alleged complaining witness. Ms. Thomas is, like, there was a text, I guess, according to my client, Ms. Thomas wanted to, drop the charges, and she does not want to press the charges. She does not feel afraid of him anymore at all. This happened on November 6, 2019. That is like more than 2 years ago. It's very old. It kind of became the completely past. And the texts were actually not from him. It was never verified by the police. It was just something that it was in her phone, and he claims that they are not his text. And he has been here in Georgia for 33 years with 3 children, 12, 13, and 2 years old. And he worked as a landscaping worker. However, last 6 months, he was not able to get a job. He has been unemployed, and he didn't graduate from high school. He has an 11th grade education. He knew about this case later, because I think he was arrested later for something else, and he wanted to take care of this issue. At the time, they didn't even have a case number, but he didn't know there was actually warrant out there. And this was kind of surprising after like 2.5 years later. So we would like to request for a signature bond for this old case, Your Honor.
All right, thank you.
If I may.
Yes, Ms. Duncan, very briefly.
Under OGCA 17-3-1, given the status of the country at the time and the COVID emergency, the statute has not told for these offenses. The defendant in this case was brought in due to a traffic stop as well, and he was driving a vehicle that was uninsured and suspended. And at that time, he was made aware that this warrant existed on March 18th, 2022, and he was brought in on these charges. So I just wanted to address the tolling of the statute.
All right, thank you. At this time, Mr. Robinson is going to receive $1,000 surety bond. He is to have no further contact with the victim, last name Thomas, and he is to stay away from Ms. Thomas's residence. The state will supplement the record with her address. He is to have no weapons, drugs, or alcohol as a condition of this bond. All right, is there anything further from either party?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Robinson. Who do we have next?
Position 16, Scroggins.
All right. Good afternoon, Mrs. Scroggins. Your case is 22 CR 001660G, in which you're charged with driving under the influence of alcohol. Let's say 2 counts with an offense date of March 21st of 2022. I've advised you of your constitutional rights. Do you object to the video hearing or to your attorney assisting you by video?
No.
All right, thank you. Mr. Howard.
10 total. Previous 9 come out of the state of Oklahoma. He had a 2015 DUI. He pled NOLO too. That's all I saw as far as DUI. Last arrest 2019, domestic assault and battery. That was dismissed.
Okay, thank you. Ms. Duncan?
Yes, Your Honor, these incidents occurred on March 21st, 2022, where officers were responding to assist other officers at the location of the Budgetel Hotel. And they were entering the parking lot traveling at a low speed at the rear of the location, about 10 to 15 miles per hour, where they observed a vehicle operating in the parking lot. The driver made a left turn driving towards the exit of the property and came close to striking the sheriff's vehicle head on. The vehicle was a GMC Terrain, as officers reported, and officers could not see the driver at the time because of the dark tint. But when they made contact with the driver of the vehicle, they informed the driver while they were stopping him and made him aware that he almost collided with the officers. When speaking with the driver of the vehicle, officers identified a strong odor of alcoholic beverage from inside of the vehicle. After further conversation, the defendant advised officers that he was heading to the store, and he informed officers that he had a few beers approximately 1 hour prior to the almost collision. Officers observed his speech was slow and his eyes were glossy, as well as his pupils were dilated. And as well as an additional odor of alcoholic beverage coming from his breath. Due to the amount of daylight, officers reported that it appeared unusual that the defendant's pupils were dilated in such a large state at that time. They asked if he had had any traumas or was on any medication, and he advised no to both questions. Due to the officers' many years of investigation and reporting, it was decided at that time that the defendant will be placed under arrest, and officers performed a series of field sobriety tests, and two out of the 4 indicators were present, and the defendant was placed under arrest. Given the facts and circumstances surrounding these allegations, the state is requesting a $4,000 total surety bond, $2,000 per charge, no alcohol, drugs, or weapons, and a defensive driving course.
Okay. Thank you. Ms. Kim.
Yes, Your Honor. Mr. Daniel is 53 years old, and actually he is a plumber who works as a contractor from different project to project, and now he's working on a new hospital where he has to travel from his city to Georgia here, and I mean he lives in Georgia but different city from Atlanta, Georgia. He divorced, and then about 3 years ago he moved to Georgia with his son, who is 31 years old, and he's the only one here in Georgia. However, he has a job that he is very proud of, and he graduated from high school, and he also has a trade education, community college, and he has a computer science skills, and his son is the only one who can bail him out. However, he's on duty right now, and he is working for military as a 31 years old. He's working for the country, and he does not have much resource at this point, and he is also responsible for child support and for his ex-wife and other children as well. So we would like to request for signature bond, and if Your Honor is not inclined to give him a signature bond, we would like to request for $250 per each charge, total of $500 bond for him, surety bond for him. Thank you, Your Honor.
Thank you. Ms. Duncan, what was the amount the state requested again?
The state is requesting a $4,000 total surety bond. That's $2,000 per charge, given the defendant's history and previous DUI issues.
Okay, thank you. All right, I'm inclined to agree with the state. At this time, Mr. Scroggins is going to receive a $4,000 surety bond, $2,000 for each count. He is to have no alcohol, drugs, or weapons. He must complete a defensive driving course, and he is not to drive unless he has a license issued by the Georgia DDS. All right, is there anything further from either party?
Nothing further,
Your Honor.
All right, best of luck to you, Mr. Scroggins. Can we do either Mr. Westby or Mr. Coles?
Position 5, Mr. Coles.
All right, good afternoon, Mr. Coles. Your case is 22 CR 0016598, and what you're charged with simple battery with an offense date of March the 22nd of 2022. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to the video?
No, ma'am.
You object to Mr. Kelbaugh, your attorney assisting you by video.
No, ma'am.
All right, thank you. First arrest, Mr. Howard? I can't read my
No.
notes. Okay, what history, please? Recommended though, correct?
Yes.
Okay,
This is 10th arrest. Last arrest was 2015, suspended registration, suspended license. He don't have any violence in the last 25 years.
okay, thank you. Ms. Webb?
Yes, Your Honor. For Mr. Coles, the bond is preset at 1,000, but we are requesting a $2,500 surety with no further contact with Miss Letitia Banks. That's Letitia, Letitia Banks, common spelling. A stay away from the incident location at 3022 Panther Trail, Atlanta. No alcohol, drugs, or weapons, and 1 day anger awareness. Your Honor, this incident occurred on yesterday when the Atlanta Police Department responded to a dispute call at that incident location, which is a rooming house. The victim, Ms. Banks, informed the law enforcement officer that she has had issues with this same defendant in the past and that he has a tendency to act aggressive towards residents at the home. Yesterday, while Ms. Banks was sitting on the patio, the defendant asked her, what did she say, and slapped her in the face. But the defendant alleges that while he was heading out of the door at that home, he somehow fell on top of her, and that is what she felt, Your Honor. As you've heard from pretrial, the defendant hasn't had any recent violent offenses, but we are concerned with a risk of reoffending, considering that the two do reside at that rooming house together. And Ms. Letitia Banks did report that she has had issues with him, and the management of that home is well aware of those issues. But this is the first time where things that she felt like escalated enough for her to call and seek police help, Your Honor. Nothing further.
All right, so when you say they live in a rooming house, they're in separate units? Are you aware, Ms. Webb?
I'm not exactly for sure the structure of the home. She just advised that she has a room in that house and that he has a room. I'm not for sure if it's like apartments in an apartment building or if it's an actual home with separate bedrooms in which they reside, Your Honor.
Okay, thank you, Ms. Webb. At this time, I'm going to sound for the victim, last name Banks. If you are present on the Zoom conference, this is your opportunity to speak. I do not believe I see a Banks. All right, hearing none. Mr. Kelbaugh?
Yes, Your Honor. As you heard, Mr. Coles does not have any violent history, at least for the last 20 years. My understanding is that I've searched the jail records in the Fulton County system, and I see that there's a Letitia Banks who's arrested in 2016 for aggravated assault, aggravated battery, and possession of a knife during the commission of a felony.
Your Honor, objection. Ms. Letitia Banks is not the defendant in this case.
I understand that. Very limited, Mr. Kelbaugh.
Well, that's the extent of my proffer, that she was arrested and sentenced on aggravated assault, aggravated battery, and the possession of a firearm or knife during the commission of a felony. Mr. Coles, for a signature bond, Your Honor, he's retired and lives on a very fixed income. If Your Honor orders that he not return to the Panther Trail address, he will find another place to live. We would just ask for one trip to retrieve his belongings with law enforcement. He denies the allegations, and we're just asking for a signature bond so that he can fight these allegations.
All right, thank you. At this time, Mr. Coles is going to receive a $4,000 signature bond through pretrial services. He is to have no further contact with the victim, last name Banks. He is to stay away from that address on Panther Trail. He can return one time with a member of law enforcement to get any items. And he is to complete a 1 day anger awareness course and to have no weapons, drugs, or alcohol. Is there anything further from either party?
Your Honor, did you say 1 day anger awareness?
I did.
Thank you.
Nothing further from the state, Your Honor.
All right, best of luck to you, Mr. Coles. Who do we have next?
At position 1, Mr. Blanks.
Oh, actually, can we take position 20, Mr. Westby, so that Mr. Kelbaugh can be excused? I'm sorry, I didn't see that in the chat. Is that possible? All right, good afternoon, Mr. Westby. Your case is 22 CR 001652Y, in which you're charged with battery family violence with an offense date of May the 31st of 2020. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to the video?
No, ma'am.
All right, do you object to Mr. Kelbaugh assisting you by video?
No, ma'am.
All right, Mr. Howard.
27 total. Last arrest was 2019, simple assault. I think that might be still open in state court. That victim was Tammy Tooley. Got a 2018 simple battery family violence arrest. 2018 failure to appear. 2018 battery DV dismissed. 2016 probation violation. 2014 probation violation. 2012 act stalking arrest. I'm not sure what happened with that. 2012 simple battery DV criminal trespass dismissed. 2012 simple battery arrest only. 2012 battery conviction out of Douglas County. 2008 battery DV that was dismissed out of Cobb County. I think that's it as far as the violence.
All right,
Yeah,
thank you. Ms. Webb.
Yes, Your Honor. In this case, the state is recommending a $4,000 surety and no further contact with Ms. Tamila Tooley. That's Tamela Tooley, Tooley. A stay away from the incident location at 2479 Abner Terrace, apartment 227. No alcohol, drugs, or weapons, one-day anger awareness, and third-party contact with any children shared with Ms. Tooley. Your Honor, this incident took place on May 31st, but Ms. Tooley reported the incident on June 1st of 2020. She stated that when the defendant came over without prior warning, he came over and asked for his fire sticks back. After she gave him his fire sticks, they had a verbal argument, and the defendant hit her in the mouth with his elbow, causing visible injuries and bleeding. She showed pictures to the officers of her shirt, as well as the bloodstains on the bedroom door at the time. She says she did not call 911 immediately after the altercation because she didn't want her kids to get involved and see police presence at the home or see the father go to jail in their presence, Your Honor. She just wanted to go to the hospital to get her injuries addressed. The officers were able to see those visible injuries on her face the following day, despite the fact that the incident took place approximately 24 hours prior to her actually making the report. Your Honor, the state is concerned with risk of reoffending and witness intimidation. As you have heard from pretrial, the defendant has an open case against the same victim under similar facts. Our office did get a chance to speak with Ms. Tooley, and she informed us that she does not wish to pursue those charges because they are married and they do share 2 children together. But considering his arrest history and that those cases were closed by the statute, those previous domestic violence cases involving Ms. Tooley were closed by the statute of limitations running, the state is concerned with witness intimidation as well, and that she's being subjected to a cycle of abuse. And we understand that when victims are subject to cycles of abuse, Your Honor, they often like to sway away from prosecution out of fear of their abuser, Your Honor. So for those reasons, we are requesting that $4,000 surety today. Nothing further.
Ms. Webb, I want to clarify that the stay away address, because did you say 24? I believe it's the same stay away address I had written down for position 10, 2479 Abner Terrace. That is the correct stay away address that you're requesting?
Let me make sure, Your Honor. That's
I believe
probably
that it looks the same. And while you're checking that, I'm getting a sound for the victim, last name Tooley. Ms. Tooley. Ms. Tooley, you would need to turn on your camera. We would need you to turn on your camera.
It's on.
We don't see you, Ms. Tooley.
Yes, sorry about that.
Okay, I pushed start camera and it says stop video, so I don't know why you can't see me.
Okay, we see you now. Hold 1 minute. Did you verify that address, Ms. Webb?
Yeah, I actually checked somebody earlier today.
Okay, hold on, Ms. Tooley, hold 1 moment. Ms. Webb, did you clarify that address?
Yes, Your Honor. I have on here 2479 Abner Terrace, apartment 227. That's in the report that was submitted by Officer Jackson.
Okay, and we had that same address for position 10 as well. Could that be correct? I guess so. All right, Ms. Tooley, would you like to make a statement today?
Yes,
But before
the
you
charge
begin,
is
please,
being,
before you begin, please raise your right hand.
yes,
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
yes, I do.
All right, Ms. Tooley, what would you like to tell the court today? Of most importance, it's your I want to hear testimony regarding your concerns for any safety you may have and the contact you may wish to have with Mr. Westby, okay?
Yeah, I don't have any safety issues. Me and my husband been together for 19 years now. So this incident was 2 years ago. So we haven't had any issues since this prior incident. And a lot has happened since 2 years. We just had a major loss. I just lost my dad and my mom. And we just became grandparents. I don't have any fear of intimidation against my husband at all. I mean, been together since I was 18 years old. So we've been living together and we co-parent. So right now is just a big issue right now because we have two smaller minor children together right now. He works in the morning, I work at night, and I get the kids to school in the morning and he gets them home from school at night. But any type of intimidation we just been together for so many years, and just so happened we got into a lot of issues, mainly dealing with money issues and bills that led to certain altercations, which we've grown from that. So, like I said, we've been together now almost going on 20 years. So I'm talking to Larry's 1 second. Yeah, so what she said about the situation about fear of intimidation, that's definitely not the cause. And I actually put a text message. I messaged someone earlier because I was here logged on since 2 o'clock. And I seen that case earlier that stated my same address. And I have it in my message that I tried to contact someone through the courthouse because that has to be wrong because I've been here for 10 years.
I heard concerns about your address. So your address, Ms. Tooley, is this 2479 Abner Terrace? Okay, so we may need to revisit the stay away from position 7. Thank you for clarifying that point and for making that statement to the court. I appreciate that, Ms. Tooley. All right.
No problem.
Thank you. Mr. Kelbaugh?
Thank you, baby. You can unmute it. Thank you. You can unmute it.
Yes, Your Honor. As you heard from Ms. Tooley, this is approximately 2-year-old case. She doesn't wish to prosecute. They're married. They've been married for a long time. They have 2 minor children together, and based on each of them working their job, my understanding is she only recently began working. Mr. Westby works as a master contractor for a courier company. So as a master contractor, he owns the vans or leases these delivery vans, and then he drives one of them and has 2 other people drive the other 2. And so he has to manage that. If he's not there, he doesn't get paid. He was driving the delivery van when it was in one of the delivery vans when it was in an accident. That's how he was arrested. Again, I'm surprised that he has not been previously informed of this because this is a 2-year-old. The incident is 2 years old, and these 2 prior cases he's been coming to court for and had a jury trial calendar on February 7th and several other appearances since the date of this alleged incident. We're asking for a signature bond, Your Honor, because he is not able to work and pay any kind of bond. And we're also asking for contact in accordance with what Ms. Tooley has asked for, so that he can assist in the care of the children and in providing financial support. So we're just asking for a signature bond and that he be allowed to have contact with Ms. Tooley as she requests.
All right, thank you. At this time, Mr. Westby is going to receive a $3,000 surety bond. He is to have no weapons, drugs, or alcohol, and to have no further violent contact with the victim, last name Tooley. I'm not going to impose the stay away at this time. Is there anything further from either party?
Thank you, Your Honor.
Nothing
All right.
further, Your Honor.
All right, best of luck to you, Mr. Westby. That will conclude your case. Mr. Kelball, does that actually conclude your business this time?
Yes, Your Honor.
All right, you can be excused. Have a good day.
Have a good day.
And Your Honor, I just wanted to update the record for position 10, Mr. Irish Hamilton. The correct address is 396 Piedmont Avenue. Looks like that's unit 2038, Atlanta.
All right, thank you. All right, are you Mr. Blount or Blunt? Pronounce your last name for me, sir.
Blunt.
Blunt. Okay, Mr. Blunt, your case number is 22 CR 00166E, in which you're charged with criminal trespass with an offense date of March 22nd of 2020. I've advised you of your rights. Do you understand them, and do you object to the video hearing?
Yes.
Okay, and do you object to your attorney assisting you on the video today?
Yes.
No, you have a problem with that, or is that okay?
It's okay.
Okay, thank you. Mr. Howard, pretrial jail first arrest. Okay, thank you. Miss Duncan.
Yes, this incident did occur on yesterday where the defendant knowingly and intentionally entered the inside of the high school at Tri-Cities High School at 2575 Harris Street after being notified by the registrar and the principal's office that he was not allowed to be there. He returned to campus and tried to blend in with the other students, but was detected and cited for criminal trespass. Your Honor, the state has a concern in this case for the safety of the minors at the school involved. Mr. Blunt is 20 years old. Given the circumstances surrounding this event and the concern we have for the safety of the students in the school, we are requesting that the bond remain as set at $1,000 surety, and we request that the court issue a stay away from Tri-Cities High School at the incident location, which is 2575 Harris Street.
All right, thank you. Mr. Ford?
Thank you, Your Honor. Your Honor, my client has no problem with the stay away. As has been mentioned, he's 20 years old. He's been working in the Wendy's fast food industry for a number of years and looking for another employment with another Wendy's here in the next few days. He's been a lifetime resident of Georgia. He does have community support. I do have a telephone number for his mother and name. He does have a stable address here in Georgia and telephone number. Your Honor, this was a misunderstanding that will be definitely flushed out in this case, Your Honor. My client has no criminal record at all, Your Honor. We feel that a signature bond would be sufficient for this case. And as I said, my client has no issue with staying away from the incident location.
Okay, thank you. All right, at this time, Mr. Blanc, I'm not going to modify his bond. It will remain as set at the $1,000 surety bond. He is to stay away from Tri-Cities High School, and he is to have no weapons, drugs, or alcohol as a condition of his bond. Is
Your
there
Honor,
any?
I do, Your Honor. You know, it's been recommended by pretrial services that he could be given an restricted judicial release, unsecured judicial release, and he has no other issues on his record, and he cannot pay for a bond. Your Honor, at this time, I believe a signature bond or some type of unsecured judicial release would be appropriate at this time.
If I may, Your Honor, that is a recommendation. However,
no need to address. Duly noted, Mr. Ford. I will not be modifying my bond issue at this time. All right. Is there anything further beyond Mr. Ford's objections, which are duly noted and understood? All right. Best of luck to you, Mr. Blunt. All right.
Position 12 is a medical reset.
All right. That concludes the calendar, does it?
Yes, we're completed here in courtroom 2.
All right. Courtroom 2 can be excused. You all have a great evening. Take care.
Thank you. You too.
All right. Bye-bye.
All right.
Miss Bridgewater, will you please reconcile the calendar for us?
I will. Long as you all can hear me, because I have a problem pulling my.
We can hear you.
Okay. All right, again, the reset date for SAP is going to be April the 5th. Position number 1 is reset to the SAP calendar with a $1,000 good bond. Position 2 is reset to the SAP calendar with a $3,000 total split bond. Position 3, reset further notice with a $6,000 SOB through pretrial. Position 4, reset further notice with an $8,000 SOB through the jail. Position 5, reset further notice with a $4,000 SOB through pretrial. Position 6 is reset to the SAP calendar with a $1,500 total good bond. Position 7, reset to the SAP calendar with a $1,500 good bond. Position 8, reset further notice with an $8,000 total SOB through pretrial. Position 9, reset to the SAP calendar with a total $2,000 split bond. Position 10, reset to the SAP calendar with a $2,500 good bond. Position 11, reset to the SAP calendar with a $1,500 total good bond. Position 12 is a medical reset till tomorrow. Position 13, reset further notice with a $10,000 total SOB through pretrial. Position 14, reset to the SAP calendar with a $1,000 good bond. Position 15, reset further notice with a $2,000 SOB through the jail. Position 16, reset to the SAP calendar with a $4,000 total good bond. Position 17, reset to the SAP calendar with a $4,500 total split bond. Position 18, reset further notice with a $5,000 SOB through pretrial. Position 19, reset further notice with a $4,000 total SOB through the jail. And position 20, reset to the SAP calendar with a $3,000 good bond. Are there any questions, comments, or corrections?
Yes, Ms. Bridgewater, did you say April 5th, like 5?
0522, that is correct.
Okay, and I also wanted to clarify if the conditions for position 14 included a third-party child contact. I'm not sure if I missed it.
Position number 14, I have it as to stay away from the victim's residence, no further contact with Ms. Danyada Thomas, and no weapons, drugs, or alcohol.
Okay, is it possible that could be amended? They do have a child.
If the judge says so, I'll do it.
So the state is requesting a third-party transfer.
Yes.
They have one child together?
As far as I know, a 9-year-old son.
Okay, they can arrange transport through a third party.
Okay, I'll mark it.
Am I gonna tell the defendant?
I'm sure, is attorney present on the screen? Who represented Mr. Robinson? Who represented Mr. Robinson? Was it
I do,
you, Ms.
Your
Kim?
Honor.
Can
Yes,
you please
I do.
let him know that he can use a third party to transfer his child?
Yes, Your Honor, I'll do that.
All right.
And Your Honor, for the MHET order, I did submit that to Ms. Bridgewater for Ms. Briggsy.
And I do have it.
Is she going to be reset to the competency calendar, or is it a reset to SAP?
It's at this time, it's just a reset from C to SAP.
Okay.
Your Honor, the correct procedure would be to reset to the
Reset to
competency
a
calendar.
competency calendar. That's correct.
I'm not sure that
I
So-
can give them the date. I can give them the date.
Yeah, once the MHET order is signed, it's to be reset to competency calendar. That's the only calendar that we deal with those cases on right now.
Yeah, and the next one for this
it's
one.
same day as SAP. That'll be the 11 o'clock calendar on the SAP.
Yes,
date,
ma'am.
correct? Okay,
Yes, ma'am.
That's fine.
So Ms. Holly, you can reset that to March the 7th. I mean, not March, April the 7th. April the 7th. I'm
April,
sorry.
and what position was that again?
9, I believe.
I have to look through my notes.
Briggsley.
Okay, no problem. Reset to the April the 7th. I
Competency
got
calendar.
Okay,
It was April the 5th.
April the 5th is that SAP. I think there's not another competency calendar until April the 7th.
Correct.
Which would be that
Calendars are
Thursday.
every Thursday.
Every
And that's
Thursday.
what we reset all the evaluation cases to.
But technically, we have heard as part of state all purpose, some of the competency mixed in. I tend to take my cases all at once. So yes, Mr. Ford.
Correct, yes.
But for the record, this will be heard on April the 7th, okay?
Thank you. That's correct.
Okay. Are there
All right,
any
now that we've clarified that, anything else from anybody?
When you back Friday?
I'm back on Friday.
Okay.
Does that